The Supreme Court chamber fell into complete silence as Justice Amy Coney Barrett leaned forward, her eyes fixed on former Florida Attorney General Pam Bondi standing confidently at the podium. What had begun as standard oral arguments in a pivotal constitutional case abruptly shifted into an unexpected and tense confrontation. Barrett, typically composed and restrained, broke from her usual calm demeanor. "Miss Bondi," she began, her voice echoing across the hushed room, "your constitutional argument contradicts established precedent in at least 3 significant decisions. Perhaps you should reacquaint yourself with Harrington versus Davis before presenting such theories before this court." The tone was sharp, almost dismissive, causing a ripple of surprise among the other justices. Bondi, leading a coalition of states in a high-stakes federalism dispute, momentarily froze under Barrett's penetrating critique. Additionally, Barrett continued, "Your interpretation of Article 3 jurisdiction is fundamentally flawed. How do you reconcile this position with your own prior legal writings?" What followed stunned not only the spectators but even the typically unshakable Barrett. Bondi's reply was a meticulously reasoned counterargument so compelling that it not only nullified Barrett's criticism but visibly altered the justice's perception of her. With the eyes of the nation's legal elite watching, Bondi calmly acknowledged Barrett's challenge and began dismantling it with impressive clarity. "Thank you for that question, Justice Barrett," she said steadily, adjusting her notes. "I'm well familiar with Harrington, and if I may, I'd like to explain why it supports rather than undermines our position." Barrett raised a skeptical eyebrow. "Please proceed," she said. Without glancing down, Bondi cited the specific passage of the decision that focused on a limited interpretation of the Commerce Clause, emphasizing a 3-part test authored in a concurring opinion by Justice Kavanaugh that justified state protections under certain conditions. She applied that test seamlessly to the present case, demonstrating that the federal regulations in question failed to meet the 3rd prong, minimizing unnecessary burdens on state governance. Bondi then transitioned smoothly into referencing Westmoreland v. United States, an obscure 10th Circuit case. Justice Sotomayor interrupted, "Counsel, Westmoreland is not Supreme Court precedent." Bondi responded without pause, "That's correct, Justice Sotomayor. However, this court referenced Westmoreland with approval in footnote 23 of Montgomery v. Louisiana, specifically when addressing federal authority limits in matters of state jurisdiction." Barrett's previously critical expression began to shift as she realized Bondi wasn't just well prepared, she was masterful. Moreover, Bondi added, "Regarding my Article 3 jurisdiction argument, I'd like to draw attention to Justice Scalia's dissent in Williamson County, which was later adopted in Nick v. Township of Scott, effectively overruling Williamson's majority view." Barrett leaned forward. "Are you suggesting that Nick's holding on property rights extends to the broader federalism context we're discussing?" Bondi nodded. "Yes, Justice Barrett, but not as a mere analogy. Subsequent lower court decisions have extended its rationale, indicating a broader trend that applies directly to the matter before us." The entire tone of the courtroom transformed. What started as a pointed critique evolved into an intellectual dialogue between 2 powerful legal minds. Other justices joined the exchange. Justice Thomas and Justice Kagan asked probing follow-up questions, which Bondi addressed with the same sharp clarity. When Justice Alito raised a possible conflict with Texas v. Johnson, Bondi deftly distinguished the two, citing details so specific that several justices checked their notes to follow her logic. Barrett returned to the conversation, her tone significantly softened. "Your interpretation is certainly creative," she said. "But wouldn't that require us to narrow our holding in Denison, which has provided a framework for nearly a decade?" Bondi responded thoughtfully. "Justice Barrett, I deeply respect the Denison framework. However, I believe the facts in this case reveal its limitations that Justice Gorsuch himself acknowledged in the majority opinion when he noted the need for nuanced analysis in unique regulatory circumstances." Bondi paused, then delivered what many observers would later call her most powerful argument. "Our case is precisely that kind of exception, a situation where federal compliance with Denison's formal requirements still erases state discretion in ways the framework was never intended to allow." As the Chief Justice noted that Bondi's time was almost up, she did not ask for an extension. Instead, she wrapped up her points with astonishing efficiency, summarizing key arguments while maintaining her momentum. Then came Barrett's final question, an intricate hypothetical blending overlapping state and federal powers, designed to probe the limits of Bondi's reasoning. The courtroom held its breath. Bondi didn't hesitate. "That's an excellent hypothetical, Justice Barrett," she said, before breaking it down into 3 guiding constitutional principles, citing precedents for each, some authored by Barrett herself during her time on the Seventh Circuit. "In your 2018 opinion in Wisconsin Manufacturing Association versus EPA," she said, "you wrote that in cases of irreconcilable regulatory conflict, courts must determine which sovereign holds primary constitutional authority over the issue at hand. That reasoning maps directly onto your hypothetical." The look on Barrett's face said it all. Not only was Bondi fluent in Barrett's judicial record, but she applied Barrett's own philosophies with fluency and respect. As if that weren't enough, Bondi brought in a concurrence by Justice Thomas from Department of Revenue versus McClintock, arguing that it offered a limiting principle that perfectly addressed Barrett's hypothetical and the present case. Several justices leaned in, scribbling notes. Justice Kagan, known for her sharp eye, raised a concern. "Miss Bondi, doesn't Justice Thomas's concurrence in McClintock conflict with the limitations established in Friedman?" Bondi didn't flinch. "Justice Kagan, the limitations in Friedman apply to interstate commerce, not the core federalism issues here. In fact, the majority in Friedman explicitly stated that its ruling didn't extend to cases where federal regulations effectively commandeer state apparatus, exactly what we're challenging today." Impressed, Kagan nodded. As Bondi continued, she offered not just deep case knowledge, but an expert understanding of the historical evolution of federalism. She traced how the doctrine had subtly shifted over decades, revealing patterns that few legal scholars had publicly acknowledged. Barrett, now fully engaged and no longer skeptical, asked one final question: "If we accept your framework, how do we prevent its misuse in future cases?" Bondi proposed a carefully calibrated 3-part standard balancing federal interests with state sovereignty, anticipating objections before they were even raised. When the Chief Justice formally ended her time, something unusual happened. Barrett requested additional time so Bondi could finish. That rare gesture revealed how deeply the court had been moved by her argument. As Bondi stepped away from the podium, the courtroom buzzed. Constitutional law experts traded stunned glances. Barrett, who had opened the session intent on challenging Bondi's qualifications, now pored over her notes with a new seriousness. The Solicitor General, scheduled to argue next, was seen hurriedly adjusting his strategy. The impact of Bondi's performance stretched far beyond the courtroom. Within hours, legal forums and commentary sites exploded with praise. SCOTUS blog published a real-time article titled "Bondi's Tour de Force Reshapes Federalism Debate," capturing what many now called a career-defining moment. What started as an attempt to expose the flaws in Bondi's constitutional reasoning ended in a revelation. The former Attorney General had not only held her ground before the Supreme Court, she had raised the bar.